So let's go ahead and talk about how you can prevent squatters from costing you thousands. So I think the first key to understanding what to do in the event of a squatter is really to understand what a squatter is. And so we're going to start by talking about what a squatter is not. So the following are sometimes referred to as squatters. I hear this all the time. I've got a squatter on my property and I got to get him out. And so I ask a few questions to make sure we're talking about a squatter, because the key difference is a squatter has no contractual obligation to you, and there's no contract upon which you can rely to get some kind of redress. There is no legal connection between you and this individual whatsoever. And so you're suing basically for no money and no ability to collect money. The following are not actually squatters, and you actually can sue for money in these situations. So the first is an unauthorized tenant. Let's say that you've got a tenant who stays, and this is very common, they've got a romantic partner, and the romantic partner comes in, and so you've signed a lease with the tenant, not with the romantic partner. In fact, you've given notice, hey, you've got an unauthorized tenant here, and maybe you're willing to add them to the lease if they just go through the application process, which they never do. And so you're at the point where you're demanding that the tenant vacate. And in fact, the tenant does vacate, but wouldn't you know it, the love interest doesn't. And so now you've got someone who you don't have a contract with. Is this a squatter? They are not technically a squatter. In fact, if you're going to sue anybody, it's the original tenant, because the tenant has not fully surrendered the property to you. They may have vacated, but they haven't surrendered the property to you because they didn't take everything with them. And but for that tenant, you wouldn't be stuck with the boyfriend who is now not paying your rent, but occupying your lease for free. In this situation, you would send a notice to vacate to the tenant, the one who signed your lease, and you would file a lawsuit on the tenant for not having surrendered the unit to you. And so you can collect a judgment, and potentially this can serve as motivation to the tenant, especially if you notify them of this procedure, probably through email, because they're not going to get messages that get sent to the rent property. If you notify them through email and say, look, I'm coming after you because you're causing me damage. They may disagree with you, but they also signed the lease and they invited a person in there who is now contributing to your losses. Not a squatter, you've got somebody you can sue. A holdover tenant is similar. Just because their time on the lease has come to an end and you've given proper notice of termination and now they are in the holdover phase, that doesn't mean they're a squatter. And so a holdover tenant is still subject to that same lease. And so they still owe rent, but they have to go because you demanded possession when you said, this lease will terminate on date X. If you're staying beyond that, I will sue you. And you do have a right to claim unpaid rent if that's the case. Even if they attempted to tender the rent and you said, no, I'm not taking that. You can, in your lawsuit, sue to recover rent because it's owed to you. But of course, you're not going to take it, because what do you create when you take that rent? You create a month-to-month tenancy, which you don't want. And it's clear you don't want it because you sent that notice of termination. So a holdover tenant is not a squatter. Finally, a subtenant is not a squatter. Now, you might have a situation where a tenant signed your lease and then they bolted. The tenant signed a lease, they bolted, but guess what? They had the forethought to find a subtenant. So now, where you were charging $1,000 of rent, they're charging $1,200. So they're even making money on the deal, but you want that unauthorized occupant, that unauthorized subtenant out. And so do you evict the subtenant? No, you evict their landlord, right? The one person who signed your lease, who again has failed to properly surrender the unit to you. Now, could you cut through red tape and say, well, I tell you what, pay me the higher rent, sign my lease, and you can stay. Sure, you could do that, but you're not required to do that, especially if it's a terrible person who never would have qualified under your normal application process anyway. You can sue the original tenant who now has a subtenant living there, especially if that violates your lease. You do not have a squatter in that case. You are suing the original tenant because they have a subtenant in place. So now that we have a better idea of what's not a squatter, let's talk about what is a squatter. A squatter is someone who takes possession of property, again, under zero legal authority. Again, in each of the prior situations, there was legal authority. There was an original tenant there who overstepped their bounds, but they had legal authority to be there. And so the person who comes in can assume that they are granted a similar or same legal authority. So there is some legal authority for them to be there. The preceding tenant who did have legal authority shifted that over to the, in this case, unauthorized tenant, holdover tenant, or subtenant. But whenever there's zero, like no one ever authorized anything in terms of possession, now you've got a squatter. And so what do you do in these situations where someone has simply stepped in under color of no lease and refuses to leave? Well, you've got a few options. And for those of you who are coming to us from states that have squatters or landlord protections against squatters, good for you. But remember, they got to match the definition of what a squatter actually is. So we're getting some comments on the chat here. All right, let's see. So Earthworm says, Ernie is 100% right. Always keep neighborhood gang members on retainer for situations like these. Thanks, Worm. You are welcome to add your contributions here. I'm not exactly sure that you're a pro Ernie guy. I've seen Earthworm in a number of my videos adding contribution, but cheers. Idlebens Alberno says, hi, Ernie, thank you for your info. You're very welcome. I'm glad to do it. James chimes in. I had that exact same situation, so looking forward to that. I'm glad, and I'm hoping all of this is helpful to all of you. Earthworm again, what Ernie said is true. Quote, you should always, as a responsible landlord, keep hidden cameras with microphones inside of the house to stay one step ahead of them. I've never said you should keep cameras on the inside, but funny you should mention it. I do advocate keeping cameras outside. And since you mention it, one of the reasons that squatters come onto property is because property is not properly monitored. If you've got a security camera that monitors the outside, you can easily see when someone steps onto your property. And by monitoring vacant property, you're able to prevent a squatter from coming in. Because in order for them to have a right to stay, a squatter has to establish residency. But if they're breaking into your home, that's a crime. And if you catch them in the act, report them to the proper authorities, and get them hauled to jail, that's your best situation. You catch them in the act, coming onto property, again, without any authority whatsoever, and you stop the whole thing right from the beginning. If property stays vacant and unmonitored for extended periods of time, you're the most likely to be hit in a squatting situation. If you've got property that's been vacant and you can see overgrown weeds, maybe boarded up windows, that sort of thing is just a haven for people who come in and use your property for improper purposes. Don't let your property fall into disrepair, and certainly don't leave it vacant for extended periods of time. You're only going to welcome a criminal element, including squatters. So video cameras are one thing. Alarm systems are another way to protect your property from a potential squatting incident. So let's see. La Tremenda 2000 says, hi, Ernie. What constitutes establishing residency? Well, that's a great question. And it's difficult to define, actually. There's no bright line test. So it's not, I've been there for 2 weeks. It's not, I definitely need to be here for 60 days. It's really going to depend on the facts on the ground. So one way to prove that you've established residency is you're getting mail at the property. You've got a property full of your furniture. You've been there for an extended period of time. Maybe you've got relationships built with the neighbors, and you've got a history at that place. That definitely sounds like established residency on the property. But there are other ways that residency is established. And one way is with a fake lease. And this unfortunately happens. So sometimes someone will come onto the property and they'll say, oh no, I have a lease. And it looks on its face very legitimate. In fact, they've got proof of payment, maybe even a receipt showing that X, Y, and Z signed this. This is why it's important to catch the entry of someone like this early on in the process. Now, is it possible that the person with the fake lease themselves was duped, that they are a victim? Yes, that's entirely possible, but that doesn't mean you have to honor the fake lease. If it's fake, they don't have an actual right to be on the property. But again, you have to be on it to make sure you prevent someone from coming into the property and moving the things in, because it's not difficult to break into a property that, again, is unsecured by cameras, doesn't have any alarms. You go in, you fix a window, you change a lock, and now you look like an owner because you have open access to the unit, and maybe you can go and find somebody out there who's willing to sign a lease and quickly move in. So sometimes you can prove residency because of the length of time you've been there, because of the way you're using the property, and sometimes in very sophisticated sorts of situations, you actually have a written lease. So how do you prevent squatting from happening in the first place? Well, one easy way of doing it, like I mentioned, is by having cameras and by having alarm systems, by not leaving your property vacant. But something else that is crucial, get to know your neighbors. If your neighbors are aware that you are a landlord and that you are in the process of leasing a property, they might be your first line of defense, because they'll see someone checking your property out, and they might give you a call and say, hey, did you set up for a prospective tenant to come check out your property? No, because somebody's here walking around the place, and I don't know that there's somebody that you have authorized. That could be extremely helpful information. Additionally, just visit your property on a regular basis. Go in, check it out, make sure everything's fine. As long as you're there on a regular basis, it's unlikely that someone is going to see an unattended property. Now, that's going to include keeping up things like the yard. Don't leave piles of paper or a bunch of mail crammed into the mailbox. You want to give the appearance that the property is currently occupied, and so you want to visit it and not give signs to someone who's looking for abandoned property. And then one extreme thing you could do is simply move in. You can come onto the property and just say, you know what, I'm going to hunker down. I'm going to take residence in one of the bedrooms until I get this thing rented out. That's another way to ensure that your property is taken care of, that eyes are on the property at all times, and your property is safe from the threat of squatting. So I hope this was helpful to you guys. If you have any questions specific to squatting, go ahead and add them to the chat. I'm happy to answer them. I'm going to keep going down. James adds, so if someone breaks in and changes the locks, you can call the police to remove them? Absolutely. That's standard breaking and entering. And if they come in, and again, there is no furniture, they have no lease, they have no proof that they've been there for an extended time, but you come in with a deed and maybe even camera footage showing, here's where he's breaking the window. You've got a very strong case, and that individual can be arrested for breaking and entering. Again, if they enter the property with a key and it's full of their furniture, the authorities are likely to say, look, this appears to be his residence. I don't know what's going on here. That's something for you to resolve with the courts. But if the appearance is a clear breaking and entering, it's very likely that the matter will result in an arrest. All right, so let them amend 2000. It's crazy that we would even have to ask about police removing a perpetrator breaking into private property and changing the locks, but here we are. Again, it comes down to, what the facts look like on the ground. Because certainly if you have someone who's moved in, who has a key, who has a lease, could someone report and say, we've got somebody who broke in and is a squatter? Well, the police are not likely to intervene in that situation and say, look, this doesn't look like a criminal act. On its face, it looks legit, so take it up with the civil courts. But again, if you've got an instance, there's clearly a broken window, someone's inside, there's no furniture, this person has no lease, they can't identify the owner or the landlord, and they certainly don't have proof of title. This is a very clear-cut instance of breaking and entering. And of course, if you're monitoring it, if you've got an alarm, if your neighbors are looking out for you, and you act quickly, you can prevent anything from ever going wrong. Okay. Idlebenz says, I just finished an eviction court-long situation for 3 months that was appealed. I found several damages. Can I sue him because his property damages about $9,000? Yes, you can always sue an outgoing tenant for property damage. The question that I always raise to landlords, it's actually two. Number one, can you find them? If you can't find them, you can't sue them, because unless you can give them notice of the lawsuit, that lawsuit isn't going anywhere. So if you can't find them, if they're gone and you can't locate them, you probably can't sue them. Second question, even if you can find them, and typically if you know where they work or where they reside, either one of those places is a suitable place for them to be served with a lawsuit. If you know where they work or where they reside, you can sue them, but you got to ask yourself, do I have a reasonable expectation that I'll be able to recover any of my losses? It doesn't matter if you have a claim for $9,000 or $90,000. If the tenant simply can't pay it, it doesn't do you a whole lot of good. And so, no, they're not going to go to jail for owing you money. That doesn't happen in this country, not yet anyway. And so that's, it may just be a waste of time. And this is me, speaking from the perspective of an attorney who does this kind of work all the time. But I'm going to recommend, if you don't have a reasonable expectation of recovery, it's probably a waste of good money on your part. And so you'd be surprised how many times I talk landlords out of pursuing litigation that just isn't going to bear fruit. Now, if there's a likelihood of recovery, then by all means, go after a tenant who you can reasonably expect to pay back any judgment that you win against them. Perhaps they own property, multiple vehicles, or maybe even they own some real estate that you could potentially seize after a lawsuit in which you have recovered a judgment, or that they have a good job and have substantial funds and can pay off a judgment. Again, if you have a reasonable expectation, definitely do it. If your expectation is they probably can't pay, even if I win, I would give that a lot of thought and maybe turn that one down. Okay, all right, let's get to our questions. I have Janice Sanchez from our email list. She says, good morning. I would like to submit 2 questions. All right, and this is out of Galveston County. Number 1, if I find squatters while my house has a lease sign out, aren't they trespassing with no rights? Can I enter and change the locks? So that depends what condition you find the squatters in. Now, first they have to meet the definition of a squatter. And so just because you have a sign out that says for lease, if the outgoing tenants left people behind and that's how they got in, again, they're not squatters. So no, you generally cannot go in and just change the locks. If you do that, you're subject to a what's called a writ of reentry in the state of Texas, where the same court that would kick out a tenant in an eviction forces you to let them back in with a writ of reentry. And so I don't know precisely what the situation is, but again, if it's a genuine breaking and entering situation, I would refer that to the police immediately. If these people, however, have established residency, and that could happen in as little as a couple of weeks. They've moved in all their stuff. They've drawn up a fake lease. They show what appears to be proof of payment, and they've got a key. All those things look like legitimacy. And so if you got to go to court and say, I never signed that lease, I don't know who these people are, and I certainly received no money from them, the lease that they have is 100% invalid. That's, again, an issue for an eviction court to review. And no, you wouldn't in that situation be allowed to simply go in. And in fact, it's usually the case that you're not allowed to go in and simply change the locks to prevent people from coming back onto your property. Unless it's a legitimate breaking and entering situation and you've reported it to the police and the police have made an arrest, that's not something that I would recommend. Second question. During inspections, can the tenant follow me while I'm doing inspections and going through my checklist? What is the process if they are home? When are findings discussed? Verbal or by email? Thank you. All right. So can they follow you? Yes. As long as they're not harassing you or they're not assaulting you in some way, people can follow you. It's their home too, for purposes of walking around. And yes, now, can they be right over your shoulder? Can they be, so close that they are physically touching you or close to touching you? No, that would be improper. Can they follow you from room to room to see what you're looking at? Yes. Can they prevent you from opening drawers or other things that are privately owned? Absolutely. You are not allowed to touch their things, open their drawers. That's certainly not allowed. Are you allowed to open closets and look in? Sure, but don't go touching the private property of your tenant. Can you pull back a shower curtain and take a look at what's inside? Sure, as long as nobody's in it, right? And so as long as you're not in some way affecting their personal property or their legitimate privacy, you are free to enter and inspect. But again, the focal point should be you're inspecting your property, the house, not their stuff. And so as long as you can, delineate that difference, you should be fine. Can they follow you? Sure. Should they be harassing you? Absolutely not. And that includes yelling at you. But here's the thing. If you're there and they're yelling and screaming and threatening you, that means that the peace has been broken. And in the state of Texas, once the peace breaks, you're no longer allowed to be there. So if you're ever in a situation where a tenant is being belligerent, I strongly recommend that you leave for your own safety. And now you may say, Ernie, I'm not afraid. I can go in. They can yell at me all they want. I'm going to be there. Well, the problem is if they call the police are very likely going to usher you out. In this situation, whenever the peace is broken by the tenant, as long as you've entered for a reasonable purpose at a reasonable time and in a peaceful manner, they are now in breach, and I would issue written notice to them of their violation. If this repeats, that's likely a pretty good basis for eviction. Now, how do you discuss these things? Always do it in writing. And I don't know if email is allowed in your lease as a proper method of communication of notice, but any communication you do give about the condition of the property and maybe things that the tenant will be liable for because they cause damage to the property in excess of normal use, in excess of ordinary wear and tear, always give that notice in writing, whether that's in a written letter that you mail to the property or whether that's in an email because your lease allows communication by email. That's up to you. But I would never, just give these notices through word of mouth. Always in a written form. So Walter Bueller asks, if they're essentially a trespasser breaking and entering, why won't police arrest them? Well, that's the key. If you're saying essentially a trespasser, that's not the same thing. They have to absolutely be a trespasser in the process of breaking and entering. If they've already broken and entered and established residency, sure, you might have evidence that they broke and entered, maybe, but in terms of possession, once they've established residency, the only way to get them out is through the eviction process, which is why it is essential to catch them early in the process. Again, if they gain access to your property and they are in the process of beginning to move property in, you can call the cops and say, whoa, there is no reason for you to be here. Show me your lease because I know I didn't sign it, and the cops are there. and they may have a lease. But if you can show the police, I'm the owner, here's a copy of my deed, this is not a lease that I ever signed. I don't even know whose name is on that lease, but it's not mine. These people need to go. Again, it could be that they are genuine victims of some actual criminal who fooled these people into believing they were getting a legitimate lease. If you catch it early enough, before they establish residency, you might be able to have the police intervene and say, sorry, I don't know where you're going to go, but you got to load this stuff back up in your truck. You don't have a legitimate lease. And unless you can produce the person who signed this right now, and we'll wait, I can't let you proceed into the house. It appears you are breaking an entry, even if they have a key, because it's not your key. And in fact, if you can say that lock is not mine, one crucial piece of information might be if you've got evidence of the lock that's supposed to be there, because you keep a picture of it. And one of the things that I always recommend to landlords is you have photographic evidence of property when an old tenant moves out. And we know in Texas, if a tenant moves out, you are required by state law to swap out that lock. And if you've done that, and kept a picture of it, particularly on your cell phone, this might be an easy way to show that's not even the lock that's supposed to be here. This is it. Somebody must have broken in and changed it. It wasn't me. They cannot stay. Now, is this going to work 100% of the time? Again, it's going to depend on a lot of factors, including what's the disposition of the peace officer who's there. How much stuff have they already moved in? Do they actually have a written lease? In a lot of cases, they don't. And so it's going to depend on a number of these factors. But the sooner you can catch them in the process, the better it is for you. But again, in your question, you say they are essentially trespassers. They have to be point blank, easy, no questions asked trespassers, not presumably. Presumably is going to get you into the eviction court. All right, Makis Kaisarutis says, by adding a no trespassing sign outside on the yard, fence, gate, as well as near the front entrance of the house, will this empower the police to arrest violations or violators once they have broken into the house without having to start an eviction process? Again, if you catch them in the act, the sign isn't what matters. The act is what matters. You don't need a sign in place in order for a police officer to recognize what a cause of action is for breaking and entering. It's literally defined in the penal code, what a breaking and entering is. Somebody's going into the property of another without authority and through forceful means. And so, having the sign and the position of the sign, not really relevant. What's relevant is how early in the process you catch them. Again, if they've been there for 3 weeks and they've moved in all their stuff, and they set up utilities in their name, forget it. They've established tenancy. But if it's the night of, and they're starting to haul, a few pieces of furniture in, again, they don't have a lease, they don't have any physical evidence that they belong there, it's likely they'll be hauled away in a police car. Especially, again, broken window, that sort of thing. There's evidence of breaking in. So again, a lot of it's going to come down to the actual facts of the situation. So, okay, James adds, the nerve of some people breaking into a place and proceeding to move their stuff in. How often do these things happen? Well, you know what? It doesn't actually happen a whole lot. The situations that I referred to earlier are much more prevalent. You're likelier to have an unauthorized occupant or a holdover tenant or a subtenant than you are a squatter. So, and the reason I mentioned this is because people are so afraid of squatters and this situation. There are ways to prevent it. And yes, if it does happen to you, man, it's terrible. But the majority of bad situations happen in the non-squatters are actually more likely to be there because you got an outgoing tenant who left somebody behind. You've got a tenant who stayed well beyond the date of termination, or you've got a tenant who decided they were going to flip the thing and make a little money and put a subtenant in their place. If you've got any of those situations, again, you want to go against the original tenants who signed that original lease. That's your best bet. And that's the likeliest you're going to recover some kind of money from the people who are residing. But always, 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 your best bet is to pursue action sooner rather than later, to be proactive instead of reactive. Whether that means putting up just a Ring, doorbell camera on your front door and leaving it activated while the unit is vacant. In fact, I like the idea of keeping that Ring doorbell cam the whole time, even when you've got new tenants, because you never know when something could happen, even during a tenancy. Now, can you have cameras on the inside? No, but certainly you can have cameras monitoring the outside of the property to prevent, theft or vandalism, or in this case, squatters from coming in and costing you thousands. So I hope this was helpful to you guys. We're going to go ahead and wrap this one up early. I appreciate you showing up. And for those of you who are interested, next week, let's see what our topic is next week. I'll be doing it live. And my goal is to do this every Wednesday at 4 o'clock. So for the 30th, can a tenant sue me if they say the rent house made them sick? We're going to be talking about injuries that happen to individuals who are staying on your rent property. I want to hear your questions on that topic. But again, if you don't get to post a question, either by getting on our email list or by being part of our Facebook group, Texas Landlords, I welcome you to join the chat, ask your question there, and I am happy to answer as many questions as I can. James says, always enjoy these, Ernie. Thanks. You are very welcome, James, and the rest of you who are out there who join us live. I appreciate you a lot. Thanks so much. And until next time, landlords, happy leasing.